Hello, dear fellow panelists and dear participants, and welcome to the DRBF Region 2 Connections webinar series, Dispute Avoidance and FIDIC Suite with Tana Dadazade, Malith Mendes, and Don Ruhukwa. I am Georgiana Dekovic, President-elect of the DRBF Board of Directors Region 2, and I'm your host for today. For those of you new to DRBF, the Dispute Resolution Board Foundation was established in 1996 by the creators of the dispute board process with the mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has over 1,400 members in over 70 countries, as the dispute board process has expanded worldwide and is now used on a wide variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners. It also partners with other industries organizations to adapt the dispute board process to new sectors. It may be of interest to note that DRBF is publishing a guide to best practices and procedures, the DB manual, which is now available in English, French, Spanish, and Portuguese. Today's webinar is the first one in a two-part series and will address dispute avoidance and the FIDIC suite. And the next one on the 7th of December will address dispute resolution and the FIDIC suite. Our speakers will share with you their own experience from Africa and Asia in particular, but also from the rest of the world. We are booked for an hour, but we could stay past a little bit, and if you have, especially if you have very many questions. For those of you who cannot attend past the hour, do not worry. The recording will be available on the DRBF YouTube channel and in the DRBF library. To introduce you now to our speakers in alphabetical order, Tana Dadazade, partner at Howard Kennedy, is an international construction barrister, dispute resolver, published author, and world-renowned speaker. He's on the FIDIC President's list of approved dispute adjudicators, a FIDIC certified trainer, and an ICC arbitrator. Tana has won the FIDIC Trainer of the Year 2020 award. Malith Mendes is a chartered civil engineer with 40 years experience, a freelance arbitrator, a FIDIC certified adjudicator, and a FIDIC certified trainer. He is currently a member of the FIDIC Certified Trainer Writing and Examination Committees, and he was an examiner for the FIDIC Certified Trainer Assessments in 2022 and a reviewer of the 2017 FIDIC contract. He is the chair of South Asia and the country representative of Sri Lanka for the Institution of Civil Engineers of UK. He has served in many standing and ad hoc dispute adjudication boards and in arbitral tribunals. He is currently the chairman of consulting company Maroc in Singapore and Mendes Gabain Consultants in Sri Lanka. Don Ruhukwa is a construction claims advisor in Botswana, focusing on both contentious and non-contentious construction and dispute resolution advisory services. He is the honorary secretary of the Botswana Institute of Arbitrators, an executive committee member of the Construction Adjudication Association of Southern Africa, and also an executive committee member of the Botswana Association of Mediators, as well as a member of the Society of Construction Law UK. And now I would like to ask Tana to start our journey through the dispute avoidance and the FIDIC suite. Tana?
Thank you very much, Georgiana, for that introduction, and it's great to be here for this DRBF webinar, and a great pleasure for me to be here together with Don again. We were together in Nairobi, which was a wonderful conference some time ago, and I'm delighted to be also co-speaking with Malice today as well. So let's kick off. What we are going to be talking about, as Georgiana has already mentioned, is dispute avoidance. And there are a number of different topics that we would like to kick around. And one of the things I wanted to mention at the outset is that I will be launching at the FIDIC Users Conference a practice note on dispute avoidance on behalf of FIDIC. And there are a few things that have been raised in that practice note, which we're also going to discuss today. And what I'm going to do, first of all, is just to introduce the concept of dispute avoidance as it sits in the FIDIC contract. So those of you who are familiar with the FIDIC 1999 Red Book and the Pink Book will be aware that subclause 20.2 makes it clear that if the parties jointly agree that they can request from the dispute board an opinion, and the idea is that that opinion could potentially help the parties to avoid their dispute without going formally to the dispute resolution processes. And there is similarly a provision in the 2017 form where things have developed a little bit, and the FIDIC 2017 form no longer uses the word opinion, but talks about the concept of informal assistance. So if the parties wish to get informal assistance from the dispute board, then they can again jointly request the dispute board for that informal assistance. And we're going to talk about things like what makes a dispute board successful, what are the important traits of a dispute board in terms of whether or not the parties have trust in the dispute board, and how dispute avoidance can particularly operate, and whether or not, what circumstances dispute avoidance will be effective. So let's just start off. What I'd like to do is start off with a reference to Professor Dr. Niall Bunny, who has very kindly written the foreword to the practice note that will be published next week. And what he says in his foreword is he tells the story about how back in the 1990s, he was asked to be a representative of both the employer and the contractor on a very large construction project in Dublin. And it was essentially his first appointment to act as a standing dispute board member. And he said he'd never acted in such a capacity before. And he had, although he'd acted as an arbitrator in a significant number of domestic and international disputes by then, it was a novel idea to him. So he was eagerly accepting the role to be this standing dispute board. So he was provided with a set of the project's documents, and he had to acquaint himself with those. And he was also asked to visit the site periodically, and he attended monthly site minutes. So all of meetings, sorry. So they're all the sorts of things that one expects to happen for a dispute board. Now, he was paid a monthly retainer fee, but ultimately the project was completed with no reference to arbitration. So he went to the opening ceremony 2 years later, to which he was invited, and he asked those that had employed him whether there were any disputes on the project, and if so, what happened to those disputes and how they were not referred to arbitration. And he asked whether or not that they had felt that the money that he had been paid, the retainer fee that he'd been paid, was worthwhile. And he says that their answer was startling. They confirmed apparently that yes, they did have numerous disputes on the project, but in each case, the parties were fairly sure of what his answer would be to any particular problem, given his involvement in the project. And therefore, the disputes were resolved by the parties themselves without a referral to arbitration. And they informed him that as a result of resolving the disputes, they had not incurred any further cost and/or time, and so paying his retainer fee had kept costs of dispute resolution to a minimum. And then Niall Bunny moves on to quote the 17th century poet John Milton from 1655 in Sonnet 19 in his epic poem Paradise Lost. And the quote is this: "They also serve who only stand and wait, which I think is rather wonderful. So essentially he was saying that he got paid his retainer fee, a particular dynamic existed on the project, disputes were avoided, there was no recourse to arbitration. So these are matters which we're now going to explore a little bit further. So let's explore, for example, what would be the best practices that one could take? What could be important for the parties in relation to dispute avoidance? Well, I would suggest that first of all, it's absolutely critical that the parties are made aware of the dispute board's dispute avoidance role at as early a stage as possible. So the first question I'm going to raise, and perhaps we can kick it around a little bit amongst our group, is whether or not it would be appropriate when a standing board is appointed at the kickoff meeting for the dispute board to, in fact, introduce the dispute avoidance role, or whether that would be potentially a bad idea. So do we think that a dispute board should be invited in the kickoff meeting to explain their role for dispute avoidance? Don, what do you think?
Thank you very much, Tana, for that. My thinking is that, as you correctly point out, early involvement of the dispute board on a standing dispute board and an understanding of each of the tools that are available for the resolution of disputes, to me, is absolutely critical. And the availability of these tools, I like to liken to a situation whereby you're driving a brand new car and you haven't read the manual. We all very often don't read the manual. And essentially, you don't want to press the button that says eject through the roof. So generally, what will happen is that someone who is the salesperson on the floor will tell you this button is only in case of emergency. This one does that. And that's essentially where we should go in terms of having the dispute board explain its dispute avoidance mechanism and how that actually differs from the situation where a dispute has occurred in reality. And we're now trying to say, how do we then follow the dispute resolution mechanism? So essentially, it's understanding the menu. Thanks, Tana.
Thanks, Don. Anything to add, Malice, at this stage? Or
Yes. The kickoff meeting is very, very important. And I believe that if it's a 3-member board, that the board members meet beforehand, before they meet the parties, and make sure they're on the same page and what they're hoping to achieve from the kickoff meeting. So the kickoff meeting is the first opportunity for the DB to start earning the trust and become part of the project team. DB has to become part of the project team with a single or 3-member. And this is the first opportunity. So it's very important that the kickoff meeting is done and explain DB's role, especially the dispute avoidance role of the DB, and also establish what kind of information the DB will require as they go along to be in conversant with the project. And they will usually, FIDIC has the usual progress report from the contractor and gives out in detail what should be in the project progress report. But any reports from the employer or the consultants is also important for the DB. So DB also should get copies of that regularly so that they have a good idea of any problems coming up, so they can exercise their dispute avoidance role to try and make sure the problem doesn't become a dispute in the first place. So the kickoff meeting is very, very important and should be planned ahead and make sure that it's effective, and that will be the first impression. Then, of course, the kickoff meeting will probably be together with the site visit, which is also important, so that they understand the layout of the site, what's happening at the site. Yes, so for the dispute avoidance role, that is one of the most important things to get done at the start itself.
Thank you, Malice. And one of the important aspects which I mentioned in the introduction is that it's necessary for the parties to jointly ask the dispute board for an opinion if and when a candidate for dispute avoidance arises. So it's not possible for one party to go to the dispute board to ask for dispute avoidance. So is that something that you think would be appropriate for the dispute board to bring to the attention at that kickoff meeting? Because I suppose if they don't realise that, then they might think, I can just ask the dispute board myself, can I have an informal opinion on this, or can I have an informal opinion on that? So I think it would be appropriate for the dispute board to make it clear that it needs to be a joint instruction. Okay, so moving on from that particular topic, why don't we have a look at the next point, which is, it's already been mentioned by Malice, it's about building and maintaining trust with the parties. So how is it that a dispute board should build and maintain trust with the parties? It's something that people say an awful lot, and there are various aspects that one can have in order to generate trust in a dispute board. Recently, I came across a triangle which talked about there being 3 elements to trust, and that those 3 elements are logic, and perhaps logic needs to be explained a little bit more. What I mean by logic is sound reasoning or sound judgment. The other aspect of the triangle could be authenticity, so that the real person that the DAB is, that personality comes out, authenticity. And then the third element is empathy. What do you think about those 3 elements, or whether or not there are other elements? How do you go about building trust? What do you think? Let's start with Malice on this one.
The building of trust comes with now, especially in developing countries, you'll find most of the DB members who are appointed and accepted and appointed are actually those of long-standing experience and knowledge of the construction industry. So there's a certain inbuilt respect and trust already there when you come in. So you have to build up on that and to be able to show that you do not favor any party. That comes into problems sometimes, especially when the nominated DB member from the employer is somebody who is a former employee of the employer. And that happens quite a lot in the developing countries. So idea should be, now they're moving away from it in developing countries and appointing DB members who have no connection or no interest with any party before. They have to, from day one, build trust in a way that so that they will be accepted as a project team member and respected for what they might advise. Of course, the fact remains that the site visit is very important to build up trust. It's at the site visit, either meeting before the site visit or meeting after the site visit, that you start talking and maybe even bring into conversation some problems you have seen and how best you can solve that problem. And that's an area in which you can get both parties to agree to accept you as a trustworthy trustworthy party, and then to be able to refer any problems they have to you and do so jointly. So the site visit is a very important time when all parties are together, including the engineer as well, if there's an engineer in the project, and to be able to discuss matters and bring solutions to any problems that they see coming up.
Thank you, Malice. Don, have you got anything that you would add on the trust aspect?
Very, very quickly. To me, the issue of trust has got to also deal with perhaps giving an indication of what would success of a dispute avoidance process look like. So the ultimate objective, what would it look like at the end, so that you can then deliver on it. And if you do then deliver on it, you would have set out what it is capable of being delivered pursuant to it, and what it may not deliver. Currently, my experience with DBs is that a lot of DB members are perceived as masters of the dark arts rather than masters of their craft. And so to that extent, it's about also making sure that the perception of dispute avoidance is understood within the context of when would it be relevant, when would it be appropriate, honestly, in appraising its value, and also acknowledging what some of the risks or the pitfalls may be. So let me pause there just before I get ahead of myself.
Thank you, Don. I mean, one of the other things that occurs to me is that in a FIDIC contract, you've got as the first tier of dispute resolution, the engineer. And the engineer is, of course, dependent on the employer for its salary. And whilst it needs to make a fair determination, that dynamic of the fact that for the rest of its function, it is deemed to act for the employer could potentially, at least in the contractor's eyes, be perceived as being in a situation where it would clearly not be independent, but also would struggle in giving a neutral or fair determination. So one of the things that is fundamentally important, and what I think is important for the perspective of getting the trust of the DAB, is the realization that the DAB is, of course, entirely independent and impartial, and the way in which the dispute board is constituted all goes towards that. So in the in both the 99 and the 2017 forms, when you appoint a DAB, first of all, the contractor will nominate a member for approval of the employer, and then the other way round, the employer will nominate a member for the approval of the contractor, and then the two parties will consult with the two members in order to get an agreed reference to a chairman. So the process of their appointment is all consensual. So nobody can possibly suggest that the DAB is not independent or impartial. And of course, both parties having to equally pay for the DAB also contributes to that independence and impartiality. Now, another thing that I think is also very important for ensuring the trust of the DAB is effective communication. I mean, ultimately, if the dispute board isn't able to effectively communicate, and that brings back the empathy point that I was raising in my introduction, if a party does not feel that it's being heard when it is presenting its position to the dispute board, and the dispute board simply doesn't have the skills to allow that party to feel heard, then I think that trust element can't necessarily develop. Okay, well, let's move.
Tanner, just
Absolutely.
a second, if I may. There is a question from Barry Tozer asking the opinion of the panel whether the more time that the DAAB is present with the parties, site visits, meetings, and so on, the easier it is to develop trust. We have included informal lunches or dinners with the party's representative as an aid to building trust. What do you think, gentlemen? Tanner, would you start?
I think that it goes without saying that building any sort of relationship involves spending time with each other. It's like any sort of relationship. So if you don't spend sufficient time with the parties, they're potentially not going to feel comfortable with the dispute board. And so they're not potentially going to even think about the idea of referring a dispute in relation to dispute avoidance. But of course, there are limits and there are times at which the dispute board potentially might be connecting with the parties on the basis of a social aspect. So if they're all going for dinner together, that's fine. But of course, that's not the time to start raising particular matters relating to the project itself. I mean, also, of course, it's important to make the point at that stage that there must be all parties present at the same time when, for example, any of those social functions are. I mean, it can be a very lonely existence for a DAAB member if they end up not being all together with the parties when they're having those social functions. Don, what do you think?
Exactly. I mean, you've said it all. I have very little to add. It's true that it mustn't become an opportunity to sort of get a leg in, so to speak, into the referrals, or to begin to sound out the DB members and to get them to express a view or other on aspects which could potentially then become part of the matters which they are going to be called upon to decide upon.
Sure. Malice, do you have anything to add to that particular discussion?
Yes, it's extremely important that that you the DB member DB meets with the parties as much as possible, have communication going all the time. And I even used to do sometimes a little bit of training session, which also becomes very good because they start debating and discussing certain matters. You know, it can be a part of the contract, a couple of clauses. And then, you know, considering I was the only certified trainer in the whole of South Asia, that's about 1 billion people, they used to like the fact that I was taking my time to come and, you know, do some training in some area. And that adds more, that adds the trust and the respect and the fact that you are imparting knowledge to them. So you become a teacher as well. So, I mean, those are things that you build up, you keep working on to build your trust between yourself, the DB and the parties and the engineer as well.
I would be a little bit reluctant to do training with the parties. You know, there is quite a bit of a debate on whether we should do that or not. At the same,
it's like, but you don't charge for it. You do a small session of training on a certain area of the contract, and that builds, you know, them debating it and them understanding it better. So, you know, adds to their knowledge. So we really appreciate. Now, recently
but perhaps,
also.
Malith, perhaps, Malith, just to build up on your point, could an opportunity not arise at a slightly earlier stage? And that's the stage at which you migrate from the procurement to the contract stage, and you're getting an opportunity for the contract managers now to sit on both sides of the contract to discuss how the contract is going to be implemented. And at that stage, the dispute avoidance mechanism you could actually not train as such, but just highlight it at that stage, at the stage at which you're migrating the contract from procurement to contract management.
Yeah. Now, recently I was in a DB and they asked me whether I can speak something about the Emerald book. They've heard about this underground works contract, but they don't know how. So, you know, I gave them basic idea of what it is, and they really appreciated that. And they were debating it, you know, considering the fact that for the first time there is, you know, one part which is lump sum and one part which is measurable. They found it fascinating. So, you know, builds up communication between the parties. So it adds to their knowledge as well, which they appreciate. So I think it's you know, it's not a formal training session. It's you know, where you charge them, but to have an informal training session, let's say a couple of hours, which works out very well.
thank you very much. Tanner, you were starting to talk about communication, I think.
Yes, I think I'd mentioned about communication. I did probably not much more to be said about that, apart from having effective communication with the parties. I think probably I'm comfortable to move on to talking about when dispute avoidance should ideally take place. And before introducing that topic, it might be worth going back to the new clause that was introduced in subclause 21.3 of the 2017 forms, and what those forms what 21.3 mentions, as I already said, is that the parties need to get the agreement of the parties. There needs to be a joint request of the parties to the dispute board, but also, unless otherwise agreed by the parties, that dispute avoidance will not take place when the engineer is engaging with its 3.7 determination process. So let's just pause for a moment and just look at the multi-tier dispute resolution provisions in the 2017 contract. So the way that the 2017 contract works is that when a contractor's got a claim, first of all, it gives a notice and then it gives its particulars. It's got 28 days to give its notice, and then there's a greater period of time now for it to give its particulars. And there's now 84 days for a contractor to give its particulars, whereas it was 42 days in the 1999 form. And now in the 2017 form, there is a split process for the engineer to try to, first of all, procure an agreement between the parties. And it's got a 6-week period, a 42-day period to do that. So if the if the claim is presented to the engineer tries for 6 weeks to try and get the parties to agree. And if he fails to get the parties to agree in that 6-week period, he's got a further 6-week period, another 42-day period, in which to give a fair determination under the contract. Now, in the event that again, doesn't resolve the dispute, then the parties have got 28 days in which to give a notice of dissatisfaction in relation to the engineer's determination. And then thereafter, it's a mandatory requirement in the 2017 form for the parties that has given a notice of dissatisfaction within a 42-day period to then refer that dispute in a formal referral to the dispute board. So what this process constitutes is a bit like a train which sits in the station at the beginning and then slowly starts to accelerate as it leaves the station. And the faster that train is proceeding down the multi-tiered dispute resolution process of the contract, the harder it is to stop that train, and the less likely that a dispute board will be able to actively engage the parties in dispute avoidance. So what can we do about that? Don, what are your thoughts about this train?
Well, as you say, as it is gathering momentum, it's a lot more difficult to get the train to stop. But equally, if you would liken the dispute avoidance mechanism to your having to buy a ticket for that train, if you've gotten onto that train without a ticket, it's a lot more difficult for you to now start saying, I didn't buy a ticket at the train station where I got on. I intended to buy one as soon as I realized. But if you're almost at the next train station, it becomes more difficult for you to actually say you forgot or you were not aware. So there's a point at which you are now no longer able to make meaningful use of the tool, which is dispute avoidance. Thanks, Dan.
Sure. So, what Malice, I mean, practically speaking, when that train's gathering speed, is it still possible for dispute avoidance to take place? Or would you agree with the proposition that the earlier you catch the dispute, the better, and the more likely it is that you are going to be able to engage the parties and resolve their disputes or avoid their disputes? What do you think, Malice?
Yes, Tara. I mean, the dispute avoidance is most effective when it's caught early, before it crystallizes into even a claim. Try and solve the problem before it becomes a claim. But I am not against using the dispute avoidance facility that's available in the DB, that they can offer to the parties. Even after the determination by the engineer, there's 42 days to be referred to a formal referral. There's still time even then to see whether an agreement can be made between the parties. The funniest thing is Sri Lanka's Arbitration Act also includes the fact that it's there in the Arbitration Act that mediation can be resorted to reach agreement if possible. And then an arbitration agreement is signed. So at every point, there's a possibility of dispute avoidance or the dispute or the claim proceeding further, and an agreement can be made. So I think if the parties would like and the DB can offer, that they can intervene at any time, even during after the decision by the DAAB. There used to be 56 days to try and reach amicable settlement, which unfortunately was reduced to 28 days in the 2017 contract, which is to my dislike. But the fact that, culturally very different, this part of the world, there's always saving face. So 28 days is not enough to save face. So therefore, 56 days was much better to try and reach an amicable settlement. So those are things. So I believe that at any point, an amicable settlement with the assistance of the DB can be achieved at any time.
Great. I mean, Sorry, Georgiana.
That's okay. Good. Tanner, please continue.
Oh, sorry. Okay, I was just going to say that I have had probably because of the clients that I've been acting for as counsel in many of the cases that I deal with, it's most unfortunate that the amicable settlement period is never used to resolve any sort of dispute, and that the actually this brings on a different subject, which is when is it that a dispute avoidance probably won't work? What are the main obstacles of which will prevent successful dispute avoidance? And so in the cases that I deal with, there is a lot of pressure on government officials. So audit pressure, for example, prevents the settling of disputes without there being a final arbitration award, or potentially, if you've amended the contract, a court decision, which is in some way final. And so what might happen is if a minister, for example, is seen to be accepting the informal decision of a DAB, even a binding decision of a DAB, and it finds that there's even a tiny suggestion that minister shouldn't have accepted that particular decision or informal opinion of the DAB, then it may be that minister finds himself in prison or at the end of corruption charges, and so they would rather not have that happening. So I don't know. I mean, it doesn't sound like that sort of dynamic is happening in many of your cases, Malice. I've had, unfortunately, that sort of experience. Is that something that's happened for you?
I find country to country, there's quite a difference in the perception of accepting a DAB decision. In some countries, yes, once a train has left the station, it keeps going until it's an arbitration award, and then only it's concluded. Others have been more flexible in accepting a solution before you go into even a DAB referral. So it depends quite a lot, different ways in which it is handled or perceived in different countries.
Thank you. I have a quick question. Sorry, Tana, for Malice, because I'm really curious. We are currently having a discussion about safe face concept in certain parts of the world, and I'm curious if in your part of the world, do you think a dispute review board would be acceptable more than a DAAB, where adjudication is not the final answer?
I think as I said again, it's quite varies quite a lot from country to country. Now Sri Lanka, of course, the DAAB decision is complied with, respected and complied with. India, hardly any dispute boards are there, other than maybe foreign funded projects. Nepal is again different. Again, it's a case of the train leaving the station and it keeps going until there's an arbitration award. So it differs in different places. But I think adjudication as a decision to be complied with, and it's could be final and binding, is something that we'll have to stick on in construction industry, I guess, to move on to be able to solve problems early enough. And of course, few countries in Asia have statutory adjudication as well. Singapore, Malaysia, Indonesia, but not most of the common law countries don't have any statutory adjudication as of now, although they tend to use some of the subclauses from British, UK statutory adjudication procedures to adapt it to Sri Lanka's contracts.
Thank you, Mali. There is a quick question, sorry, before we move further, from Ralph on the Rule 7, paragraph 1. Could be a last escape route, or in other words, a temporary emergency brake for the train that the DAAB could pull during the hearing. Comments, gentlemen. Don, or Tanner, sorry.
No, Don.
I didn't get that. I didn't get that.
Sorry.
Can you repeat?
Rule 7. Hang on, I'm losing the question now. Okay, Rule 7, subparagraph 1 could be a last escape route, or in other words, a temporary emergency brake for the train that the DAAB could pull during the hearing. Comments?
Well, I'm not too clear on it. Please, Tana, would you go first? Because in which sense could it be an emergency brake is what I needed context on.
Oh, sorry.
So I think what the question is driving at is whether or not there's a chance for the parties to pause. So I love the idea of an emergency brake on our train. And whilst we're talking about the train accelerating, there are going to be possible opportunities for parties to engage the dispute board at any stage, at any point on that train, as long as the appetite is there from both parties. So, I mean, I've had examples where you get all the way up to arbitration and parties can then settle a dispute between themselves, perhaps not with the assistance of the dispute board, but ultimately I mean, of course, by that stage, the dispute board's long gone because you're in arbitration. But the point is that you can get to a situation where the parties can potentially settle at a later stage as the matters progress. I mean, some people talk about potentially engaging mediators in processes of arbitration when, for example, the pleadings have closed. So imagine that you've had the request for arbitration in our ICC arbitration, then the various memorials are exchanged. Instead of going to the final hearing in front of the arbitrators, it may well be at that point that the parties can have in front of them the dispute board's decision that came before, maybe an opinion as well, the exchange of memorials, and then let's go to mediation and let's use all that information now that we've really got a clear understanding of what each party's position is. And so that would, there would be a possibility of dispute avoidance.
But to what extent then, Tana, would you then say that that could impact on the purpose of adjudication being a quick and speedy remedy, could it not then be used by a party who's not acting in good faith to merely just, if you like, pull the emergency brake for the sake of disrupting the journey and nothing more?
It's a very, very good point, Don. I mean, I've literally just come out of a situation where I was sitting as an arbitrator, and in the arbitration, the contractor had made 10 referrals to the dispute board, and they had started to get fed up because the employer wasn't paying any of the dispute board's decisions. And they then decided they're just going to refer the final decision directly to arbitration because it arose late in the stage. And ultimately, they were thinking, you know, these processes, I keep on having to go to this DAAB. I'm fed up with going to this DAAB. It's not helping. And frankly, I would rather just get the matter resolved. I want to go to arbitration, and I don't want somebody to pull the emergency brake of the train in the middle of my arbitration so that we can have a mediation, because all this is time wasting. And, you know, when this time wasting is happening, they're trying to kick the can as far down the road as they can before ultimately the payment needs to be made. So yes, I can see that tactically it can be potentially abused. But if there's goodwill, and I think you put your finger on it, you were saying if there's bad will, then it can potentially be abused. If there's goodwill, then it might be possible for these sorts of techniques to be used for emergency brakes to be pulled and for all sorts of things, other activities to take place in order to resolve disputes before final resolution in an arbitration award.
I will say this, Tanner. One of the tools I've often used to good effect is a tool that we use in mediation, which is called reality checking. And when you reality check the parties, very often they lose track of the fact that given the value and what's at stake in the adjudication, sometimes you lose track that after all the experts have come in, expert witness reports on both sides, full arguments by counsel, instructed by attorneys, that at the end of the day, you actually see that the relief in terms of monetary sums that you are claiming, at the end of the day, the parties have lost sight of that. Somewhat like going to an auction and then outbidding your competitors, only to find you've paid 3 times what the commercial price for that particular item is.
Sure. No, I hear that. I mean, another thing, just running with that, is that I also have experienced that one of the big problems, and again, an obstacle preventing successful dispute avoidance, is when the decision makers from each party are not present or engaging in the potential dispute, the process of trying to resolve things. So if you don't have a decision maker present, then it's next to useless. By contrast, if you do have decision makers in the room at an early stage, then that could be the recipe for a resolution much earlier. I mean, I had a case relatively recently where I suggested to my contractor client that we ought to go to a high-level meeting with the minister and raise, because it was a very isolated legal point that needed to be resolved. There was a lot of money hanging on this particular point, but it was only one isolated legal point that needed resolution. So I suggested that we simply had a meeting, a high-level meeting in the offices to thrash out what it is that needed to be discussed, and that might at least set out the scope of the dispute for potential resolution. It didn't work in the end because of the bureaucratic nature of the employer, but it was something which could have worked in a different environment. And that also asks the question, what is the actual question for dispute avoidance that is going to be potentially addressed by the DAAB? And this is something I'd be really interested to hear, Malice, from you on what are the topics that are usually effective for a dispute avoidance subject. So what's your experience there, Malice?
Dispute avoidance, as you know, is something that has to come right from the start, to the point where the dispute board is aware that a problem is brewing. And to do that, they have to have enough information and be able to visit site regularly, and when whatever they see some problem that is brewing in the site, they can bring it into conversation. So there are quite a lot of things. Now, I can give us an example. I was DB for several six packages of roadworks. They were rural roads, and each package had 20 roads, several kilometers long. Now, when they came to the process of completion and taking over, they were having a lot of problems because 20 roads taken over at 20 different times, with the DNP running and completing at 20 different times. They're going to have a lot of administrative problem on managing the contract as far as defects notification and defect rectification is concerned. So, I suggested, why don't you package it into, several sections, maybe 4 sections or 5 roads each, and you take a section, one of the sections over, and then it's much easier to manage. So, so what could have caused disagreements, disputes, has now become much easier to do. So dispute board's role of dispute avoidance is to see a problem coming up much ahead and see whether a solution can be offered. Of course, both parties will have to, agree to it or also request that, can you provide us a solution? As you know, a good dispute board doesn't have any disputes referred to them. And I tell them that all the time at the kickoff meeting. And some of the data from US shows that 58% of projects where there are dispute boards, no referral of disputes to them. So why do you want the dispute board, they might ask. But that is the role of the dispute board, to avoid disputes. That's the most important fact to do. And I tell them that. And I've had projects where I was dispute board, not a single dispute referred to me, a formal referral, because I solve problems before it becomes a claim and a dispute. So that's where it is. So dispute board has to be aware of what's going on, be very aware of what's going on in the contract and in the works, and to be able to bring into discussion problems that the dispute board sees. The dispute board will be a very experienced construction personnel, or you've been in construction industry for a long time. They will see problems coming up and be able to solve problems.
Thank you, Matt. So one of the things that makes me think about is where you have a dispute board potentially trying to identify a particular area of dispute that the parties might wish to refer to them, then it could have a counterintuitive effect. It could be the opposite of what you're wanting to achieve, is the avoidance of dispute. Instead of that happening, what might end up happening is that litigious parties might start thinking to themselves, oh, that's a good idea, maybe I could claim on that, or and that might not be such a, I mean, that's one of the things that I was thinking about recently, where I mean, if for example you give a list of things to a party as to what might be the subject of dispute avoidance, you're possibly shooting yourself in the foot. What do you think about that? Don, do you have any comments on that, or Malice?
Yes, I think that's a fair risk that you could actually be loading the gun, so to speak, because to the effect that it may not have been in the contemplation of the parties that a dispute could have been avoided in a particular manner. Let me give you an example. I've come across someone, a client, who's said to me, well, look, dispute avoidance, I'm avoiding a dispute simply by allowing the DB to make the decision and that way it can't be blamed on me. So therefore, I've avoided disputes, but that's not quite what is envisaged by dispute avoidance. We're looking at actively making sure that you do not have the powder keg that then results in the dispute going through the formal dispute resolution mechanism. But unfortunately, a lot of clients seem to, especially employer clients, seem to want to avoid being in the room to take the decision to say, let us avoid this dispute by taking this concrete action. I find people who are more amenable to that are the persons who are responsible for actually administering the contract and who know what the effect of a dispute could be on the project itself. So if the benefits of the dispute avoidance on the, let's say, the time taken to resolve, as well as the unforeseen time consequences, the length, the extended length, and a lot of the unforeseeable things that come along with that. Once people realize that, they're a lot more appreciative of the role that avoidance can play in actually enhancing the project objectives.
Yeah,
Can if I may also, yeah, if I may speak, because in the last several years has been rather difficult in the construction industry. COVID for about 2 years, then financial crisis in some countries, and then also unusual rain patterns, which has also become a rather a large topic of discussion in dispute boards. So I think the dispute board, to be able to give ideas on how the matter can be solved and can be to the point where how it should be, how the contractor could be compensated for unforeseen situations, is something that has to be appreciated, I feel. And I think that DB's dispute avoidance role and solving problems in the last 3 years has been most acute due to these factors. Hopefully better times to come, but let's see.
Are there circumstances, going back to our analogies, that dispute avoidance might constitute a poisonous bullet? And what I mean by that is, imagine if a dispute board gives an informal opinion, and then the contractor, for example, doesn't like this informal opinion. Then they're going to have to go to the formal referral. And in that situation, they know already what the DAB is thinking. And so what do they do about it? They need to try and see if they can find other arguments or potentially different evidence. And then they might think to themselves, gosh, I wish I hadn't gone to this dispute board in the first place, because they've come and given me a decision against me. Is that dynamic something either of you are familiar with?
Well, not really on my part, but what has struck me is because DBs can, when they've at a particular point in time with the information they have at their hands, could have a certain thought or attitude towards avoiding a particular dispute, which in the circumstances, had they had all of the information which you will now have in the formal dispute resolution process, they would have actually changed their mind. Now, how easy is it for the dispute board members to turn away from a position that they've given previously, except otherwise than saying that the circumstances were we didn't have all of the information? It's normally very difficult for DB members unless they can justify a departure from the advice that they've tendered to the parties. So to me, really, that's the way that I would look at it, that it's highly unlikely that a party who has tried a particular, who has seen what the DB's attitude is, would quite often in the formal dispute resolution engagement actually try to address the shortcomings or the position that would strengthen that which the DB found wanting on their part, if you see what I mean.
I think dispute board. That's one of the things that dispute board has to do is to explain their role and the dispute avoidance role, and make clear that whatever opinion or assistance that they give at the dispute avoidance phase does not necessarily mean that they might have a different decision when it's referred to them with all the information required to make a decision. I think that has to be done. And you know, now one of the examples I had was, you know, the Asian Development Bank road projects usually have the construction phase, and there's another 3 years of performance-based maintenance of these roads. So they usually it's one long contract, and they usually can require 2 performance securities, one for the construction phase and one for the performance-based maintenance phase. Now, one of the cases, and it was quite repeated in so many contracts, was the fact that the BOQ had only one item for a performance security, while the particular conditions made it very clear that 2 performance securities are required. And then this was also discussed at the pre-bid meetings, and the requirement for 2 performance securities were made very clear. So the contractor was not happy that he's getting paid only for 1 performance security because there's only 1 item in the BOQ, but he should get paid for 2 performance securities. So I did have a look at it very well, and they wanted an opinion from me on that under the Pink Book. And I said, you know, it's very clear that this has been discussed, and it's also very clear in the particular conditions, and the particular conditions are clear that 2 performance bonds are required. So therefore, you will get paid for whatever you have quoted in the BOQ. Now, even if the BOQ did not have an item for a performance security, they still have the obligation of producing, submitting 2 performance securities, even if there's no item in the BOQ. So once that was understood, they decided to leave it at that and not go any further. So that was a festering problem that the parties had, which was brought to my attention, and I believe I solved them going any further. So that's where you know, using this dispute avoidance role is very important. Explain what the dispute avoidance role is.
I'm curious about, Matt. Sorry, I think you cut off a little bit there.
I see. Hello.
Sorry, one of the things that I am now interested in asking, following that interesting account, Manis, is when you are giving the informal opinions, are you giving them in writing, or are they in an informal discussions?
I will give them in writing, but I will meet with both parties to discuss the matter before I do give the opinion in writing. Yeah, and I will also say, as per the contract, this is not binding, based on the information that I have right now, and make sure that they understand that.
Sure. And so do you think there are circumstances where it's going to be effective to just have an informal discussion without anything being put in writing by the DAB? Or is it usually the case that the parties would like to have something in writing from the DAB?
When it comes to government projects, yes, they do like to have something in writing from the DAB. So,
sure.
So I do that, yes.
And what about your experience, Dom?
Well, my experience is that generally parties want something in writing, usually because the decision makers are not those who would have been involved at a technical level. So, for example, your permanent secretaries or your ministers, they would be saying, oh, well, we've got to actually get the clearance to any outcome of any process of this kind would have to be approved. So they would say, we don't want to misquote you, so can you put your your informal assistance or your advisory opinion in writing so that we can then attach it to our recommendation.
Sure. And I imagine that there's also the possibility, a bit like the example I gave right at the beginning of the webinar, where Niall Bunny didn't say anything at all. He's just stood and he waited, and his presence was enough for there not to be anything in writing, let alone, and not even a discussion. So that's the other extreme. So it could potentially work with oral in certain circumstances.
Yeah, Ted, I was a contractor for 15 years, and I really wish DABs were there in place at that time in those contracts. You know, just little problems festering into larger number of problems, and then finally ending up in arbitration. I have a case where I was 2-year project putting up a building in Colombo, went on for 7 years of arbitration. You know, a total waste of time.
Yeah, no,
I really wish I had DABs when I was younger.
And equally, Tanner, I've been involved in a project whereby there were certain claims relating to extensions of time, delay claims, but neither of the parties had actually terminated the contract. So when you begin to try and look at unraveling all of this, we had a very senior and experienced DB member, sole DB member, who then brought it to the attention of both parties that, look, my advice to you is that as neither party has actually terminated the contract, the financial consequences of any decision I make will depend on which of the scenarios. So can you address me on essentially what the scenario is on both parties' side? And then both parties then went away and each then hurriedly put in notices to terminate, which met cross air, but eventually it was achieved that you were now able to see that if it was capable of avoiding the dispute, you would know what the financial consequences were. So sometimes it is worth having a seasoned DB, and where they trust that party and their expertise and their knowledge, both parties are more likely to then take that role more seriously.
Jim Perry talks about one of his experiences, which I find very interesting, where the joint venture, the lead joint venture partner went into receivership, and the employee was to terminate the contract. But the DB was asked for assistance, and he managed to restructure it. They managed to restructure it in a way that one of the partners will take over as a lead partner, save the contract, and finish the project. So that's where, you know, DBs can be very effective.
Fantastic. So I think we're probably running out of time. So concluding remarks, I think, probably in order. And I mean, my own concluding remarks are in my I mean, basically parties are encouraged to engage in dispute avoidance as early as possible and throughout the project. And for me, it will be something that will achieve successful completion of the project, maintain amicable and successful business relations, and avoid unnecessary additional costs of protracted disputes. So dispute boards should help the parties to achieve those objectives. That would be my conclusion. What about you, Don? How would you conclude?
Well, for me, I'm a great believer in the saying of Captain Jack Sparrow, Pirates of the Caribbean, that he's always saying, why fight when you can negotiate? It is always better to use your jaw, than to war. Those are my remarks.
Wonderful. Malice.
Dispute boards and dispute avoidance are a gift to the construction industry. And I believe that they should be made effective as much as possible. And thank God for it.
Georgiana, I think that brings us to the end, unless you think that we need to answer any questions.
I had a quick look. The only question that is left unanswered, it's dealing with the new power given by FIDIC 2017 to the engineers, and is asking for your practical view, gentlemen, on this double hat function of the engineer.
The double, as in trying double hat?
Yes.
Okay, so what, the fact that they are deemed to act for the employer on the one hand is one hat, and the fact that they are neutrally making, the new word of neutrally is used in the 2017 form when it comes to the obligation on an engineer to give a fair determination. I think under the 1999 forms, it was not clear whether or not the engineer, when making a fair determination, was doing so whilst at the employer. Some people would say that it was an exception to the engineer's obligation of acting on behalf of the employer when it's making a 3.5 fair determination. And the suggestion is that in the 2017 form, that particular ambiguity, if you like, has been ironed out because of the fact that it makes it absolutely explicit in the 2017 form that the engineer is acting neutrally at the point that he's making a 3.5 fair determination. If somebody's saying to me, is it realistically possible for an engineer that depends on its salary from the employer to make a fair determination neutrally? The answer is, of course, it ought to be possible. However, in the event that it doesn't happen, and in the event that the engineer is put under an awful lot of pressure from the employer to give a decision or a determination which is against the interests of the contractor, for example, the whole reason for the dispute resolution provisions in the contract and the presence of a DAB is for there to be recourse for that contractor further down the line. So I think in principle it is possible for an engineer to make a neutral determination. And in fact, an engineer that doesn't is probably not serving its employer that well, because otherwise it could have potentially, if it did give a neutral evaluation and it was fair and the contractor considered it to be fair, then that dispute would have been resolved at an early stage rather than it having to go down through the various tiers. So I think that's all I have to say on that subject.
Would you like to add something? Or
I think the provisions in 3.5 for an engineer not to act for the employer while executing his duties under the subclause was very welcome by engineers of the world. So I was myself review of 2017 contracts pre-publication. That's something I thought was a game changer. So I think that works out very well.
thank you, Don.
I've seen an engineer's determination made on the letterhead of the employer. And to that extent, to what extent could that be deemed to be neutral? That's all I've got to say about that.
Oh, thank you. So, gentlemen, thank you very much indeed. And I would like to invite you all to join us next time on 7th of December for the dispute resolution and the FIDIC Suite with our speakers today, Tanner, Malith, and Don. Thank you very much and have a good week.
Thank you.
Thank you.
Thank you, everybody. See you next week. Bye.
Thank you.
Thank you.